Good afternoon, everybody. Before we start, I would like to make one request of the audience, and that is those of you who have cell phones or other things that might go beep or wonk during the lecture, please turn them off. 218 years and 2 days ago, September 17th, 1787, the delegates to the Federal Constitutional Convention met for the last time to sign the United States Constitution and to present it to the American people. 39 of the 55 delegates, all men, who had met in Philadelphia over the long, hot summer, actually signed the Constitution. Many had to leave before signing, and actually 3 of the members present at the end refused to sign the original document. It's been an interesting ride. Changes to the Constitution began almost immediately with the addition of the Bill of Rights, the first 10 amendments to the original document that were ratified only 3 years after the Constitution itself. We're at number 27 and counting. Today, to commemorate the signing of the Constitution, we have arranged a special talk by one of Harvard's and the nation's most celebrated constitutional scholar, Carl M. Loeb University professor Dr. Lawrence Tribe. Larry Tribe came to the university in the late 1950s to study mathematics, but after graduating summa cum laude in that subject, and even starting on a graduate career in the sciences, we lost him to a much higher calling. J.D. 1966, clerk first to the California and then the United States Supreme Court, and on the faculty of Harvard Law School since 1968, Professor Tribe has not only written on physics, a subject near and dear to my heart, and the law, but arguably the most influential legal textbook of the 20th century, American Constitutional Law. He has a one-loss record in arguing before the Supreme Court that would make the Red Sox proud and the Yankees envious. Without further ado, I give you Professor Tribe to speak on remembering the Constitution's future, anticipating the Roberts legacy.
Thank you all for being here, and thank you, Professor Hookra, for that nice introduction. The weather is much too pleasant to justify a lecture about the Constitution, but as you'll see, this is rather an obligatory performance, but I'll explain in a moment. There were 3 things that led me to accept when John called me in late August and invited me to do this. One was my assumption that John Roberts would by then have been confirmed as Sandra Day O'Connor's replacement because his confirmation hearings were in fact set to begin on June 6, making this a timely topic and not arguably one that jumped the gun. 2, I noticed that apart from being the vice provost for research policy, Professor Hookra was the professor of cosmology at the Harvard-Smithsonian Center for Astrophysics, appealing to my deepest subterranean fantasies about pursuing black holes and 11-dimension superstrings in my next life, should there be one. And number 3, I found it intriguing that the invitation to deliver this lecture was traceable to a writer, Section 111 of Public Law 108-477, to last year's Consolidated Appropriations Act, duly gray-sounding measure, requiring Harvard University, and indeed every other educational institution in America, either to provide an educational program on the United States Constitution, on or near Constitution Day, September 17, whose origin you've already heard about, or lose all federal funding, which includes all money from the federal government for student scholarships and fellowships. So you see, this was not exactly optional. Immediately, that made me think of one of the most fascinating of the cases that the Roberts Court, as it seems sure to be by then, will face in the coming term, the case of Rumsfeld against Fair, with the Secretary of Defense challenging a ruling by the United States Court of Appeals for the Third Circuit, which found that the threatened cutoff of all federal funds from any college or university, any one of whose departments fails to provide adequate recruiting access to the U.S. military for whatever reason, a violation of the First Amendment. I shouldn't quite say for whatever reason. That is, colleges that historically have had a religiously grounded pacifism are exempt from the requirement to give access to the military. And indeed, the entire scheme, though described by the United States government in its brief to the U.S. Supreme Court as simply a requirement of equal, non-discriminatory access for the military, is something, at least as administered by Secretary Rumsfeld, that looks very different. Where in the statute he thought he got his authority is unclear, because the statute reads the way the government describes it, as a requirement of equal access. But the position of at least 50 members of the Harvard Law faculty, including the one who's standing in front of you now, and a amicus brief being filed today in the U.S. Supreme Court, is that properly understood, the federal statute requires only that there be some neutral recruiting criterion. And we think we have a neutral recruiting criterion. Namely, if you have a bigoted, discriminatory hiring policy, you're not welcome. Indeed, the Harvard program goes further than that. It says you're welcome, but not very. That is, if you represent a law firm that says no gays unless they are closeted, we won't let you recruit really at all. But if you represent the U.S. military, which pursues exactly that same policy, you can recruit, but not using the privileged perch of the placement office. From our point of view, we're providing equal access, non-discriminatory access. And therefore, in our view, the statute properly understood hasn't been violated by us or any other law school or university that we are now aware of. And the whole thing is a lawsuit that oughtn't really to be before the Supreme Court in this form. The parties seem to agree. That is, Rumsfeld wants to call it equal access, and this group called FAIR wants to go along for purposes of launching an interesting and important First Amendment challenge to the law. It's our view that the parties don't have the power, by misconstruing the statute, however mutually, to confront the court with a constitutional problem that is better avoided. Well, the argument that FAIR wants to make under the First Amendment, though I happen to agree with it, is not agreed with by all of my colleagues, partly because there's a certain difficulty in arguing that the Solomon Amendment, as it is called, the federal statute, imposes some pressure or compulsion on a university like Harvard to make statements against its will, or to join arms with an enterprise that it regards as odious, because there is no literal requirement that we say something or lose our money, although as administered there is a requirement that we put up various posters. In contrast, Section 111, pursuant to which I stand before you, is rather easy to challenge as compelled speech, because it literally requires that the university put on some kind of speaking activity, educational activity at least, which presumably requires communication, or else lose its money. So it's really a case of our money or